Hello, my young friends. Today's subject of discussion is about insurgency and human rights issues in the Northeast as an aspect of human rights and value education. In the appreciation of the aspects of insurgency and human rights issues in the Northeast, three terms will require to define. Those three terms are insurgency, human rights, and Northeast. Insurgency may be defined as the state of political revolt in a state. It presupposes a civil war. It is insurrection, which means a war of citizens against the state government for the purpose of obtaining power in the whole or in part. It implies an armed struggle by a group of citizenry against the government. By human right, we may refer to the definition of the terms, which is defined as the rights relating to life, liberty, equality, and dignity of the individuals, guaranteed by the Constitution or embodied in the International Covenants on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, adopted by the General Assembly of the United Nations on the 16th December 1966, and which are enforceable by the Indian courts. The term Northeast states denotes the states of India popularly known as the Land of Seven Sisters, consisting of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. It is pertinent to point out that much has been talked about insurgency problems in these states and resultant violation of the human rights being rampant, which is the subject of discussion here. Not to the causes of the insurgency, but to the study relating to human rights issues that cause to the people due to insurgency problems prevalent here. Now, we come to insurgency and international law. Insurgents are not treated as pirates, but until they are given recognition as insurgents, they are treated as public enemy. Once they are recognized, the international rules of war and the international humanitarian law become applicable to them, and they are bound to observe them. The essential conditions for recognition of insurgents are that they must have control over a considerable part of the territory. They are to receive considerable support from the majority people living in the territory, and they must have the will to carry out international obligations. Many armed conflicts of the characters said to be national or international can be seen to exist within the states of Northeast, which even though not recognized as insurgency in the strict sense that is used in the international law, but still there are conflicts which people call them to be in fact insurgency, assuming armed rebellion for demands of homeland to form a separate nation, integration of ethnic groups into one, demands for recognition of independence from the dominant political and cultural hold of the established governments, etc. These armed conflicts, which are called in common parlance as insurgency, have resulted in the violation of the human rights of the common people. Also, the insurgents and the members of the armed forces as well. The conflicts have side effects and claim mostly the human rights of the civilian population at large who do not take part in the altercation. Therefore, it is imperative to keep an eye to the aspect of the human rights issues which resulted due to the existence of the insurgency problems. The human rights issues. Human rights and fundamental freedoms allow us to fully develop and use our human qualities, our intelligence, talents, our conscience, and to satisfy all spiritual and other needs. Human rights are not created by any legislation. They assume the position of natural rights. The Universal Declaration of Human Rights 1948 consists of a preamble and 30 articles covering both civil and political rights and economic, social and cultural rights. The preamble refers to the faith in fundamental human rights, in the dignity and the worth of human person, and in the equal rights of men and women, which the people of the United Nations have reaffirmed in their charter and their determination to promote social progress and a better standard of life in the larger freedom. The Constitution of India, which came into force since the year 1950, contains a bundle of guaranteed rights in its Part 3 called the Fundamental Rights. One important guaranteed right is the right to life and personal liberty, which cannot be deprived of by anybody or authority except in accordance with the procedure established by law. Here, John Stuart Mill, in his own Liberty, may be quoted. The only condition under which power can rightfully be exercised upon individuals is to prevent greater harm to the society. When there is armed rebellion, or in common parlance to be armed insurrection, naturally there is need to enact legal provisions and to empower the executive authorities to take up appropriate measures to repel such activities in the interest of the general public. When powers are conferred, then such powers are bound to be abused, and the whole subject of the administrative law confines upon the aspect as to how to control these powers that are conferred upon the executive authorities from being abused. For this reason, one may have a look into the provisions of law concerning control mechanism of such acts of armed insurrection. We come to legal provision and the control mechanism of insurgency. In the study of insurgency and issues of human rights, the provision of proclamation of emergency under Article 352 of the Constitution may be referred to. In case of armed rebellion, the provision may be resorted to by the government. The provision goes as if the President is satisfied that a grave emergency exists, whereby the security of India or any part of the territory thereof is threatened by war or external aggression or armed rebellion. He may by proclamation make a declaration to that effect in respect of the whole of India or of such part of the territory thereof as may be specified in the proclamation. While proclamation of emergency is in operation, the executive power of the Union shall extend to the giving of the directions to any state as to the manner in which executive power of the state shall be exercised. As regards the fundamental rights of the people, during the proclamation of emergency, the right to life is kept sacrosanct and put beyond the powers of the precedent to suspend it. This provision may be said to be a mechanism to control armed rebellion in any part of the territory of India by proclamation of emergency in that part of India, and central government may give suitable directions as may be permissible under the law of India in order to control armed rebellion. But the government did not resort to this provision, as the proclamation has a short lifespan of only 1 year. There are general criminal laws and procedures that may be relevant to the subject of study. There are special laws as well in the matter also, which requires attention. So to come to the point of special law that requires special attention, the act known as the Armed Forces Special Power Act 1958, formerly known as the Armed Forces Special Powers Assam and Manipur Act 1958, was to enable the exercise of certain special powers that are conferred upon the members of the armed forces in the disturbed areas in the state of Assam and Union Territory of Manipur, which is extended to Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram and Arunachal Pradesh. Under the Act, a disturbed area means the area declared by notification to be a disturbed area by the central government. A commission officer, warrant officer, non-commissioned officer or any person equivalent in the rank in the armed forces is conferred where within the area declared to be disturbed, any prohibitory order is issued prohibiting carrying of any dangerous weapons. The members of the armed forces can destroy any hideout or place used as dumping of the arms and ammunition and arrest any person who is connected with any cognizable offense. While doing so, such a member of the armed forces may arrest any person and hand over the arrestee to the nearest police station with least possible delay. In doing so, such member of the armed forces may, by giving necessary warning, shoot at the crowd to the extent of causing death. The armed forces involved therein are given immunity from prosecution or initiation of the legal proceedings against them except by a sanction from the central government. This special law has been called into question in the Supreme Court of India, challenging the constitutional validity of the same for being violation of right to life guaranteed by the Constitution of India. It was also argued that the powers conferred to the armed forces are said to be arbitrary, as the law has singled out the population of the Northeast than the rest of the country for hostile treatment without any reasonable classification. The Supreme Court examined the contention for and against the law in the Naga People's Movement of Human Rights versus India, AIR 1998, Supreme Court 431. The Supreme Court refused to hold the said law to be unconstitutional, but the said law has been made to be in force subject to the requirement of compulsory review of the order declaring disturbed area status every 6 months so as to decide as to whether to extend the status further for another 6 months or to withhold extension then and there. The law is still in force. We may refer to the judicial reaction also. Numerous allegations are leveled by the people that armed forces deployed in the various sensitive parts of the region perpetrated random human rights violations, very commonly custodial deaths, arbitrary arrests, detentions, etc. There appear numerous cases before the Supreme Court and the High Courts. To mention some such cases are Kamini Bala Talukdar versus State of Assam, 1997, Criminal Law Journal, 874 Guwahati. Sebastian Hongre versus India, AIR 1984, Supreme Court 1026. Potsamam Ningol, Thoksom versus GOC Imphal, AIR 1997, Supreme Court 3534. There have been cases of the rape of women by the armed personnel, for which some of them had to stand before the court martial and face conviction and sentence of imprisonment. This scenario is a narration of only a part. People curse the law known as the Armed Forces Special Power Act 1958. Someone even opposed the law by resorting to fast unto death. There has been institution of a commission appointed by the central government with the entrustment of the terms of reference as to whether the law is to be continued or repeated. The Supreme Court and the High Courts are alive in evolving law of compensation against the government in exercise of public law remedy under the constitutional mandate in appropriate cases. When the court finds cases of deprivation of the life of the people without due process of law by the state or central government. The theme insurgency and human rights issues in the Northeast has many facets to appreciate the problem. Viewing the subject mainly by projecting to the importance of the human right, legal remedies and strategies, it requires to sensitize the people about the legal measures to enforce human rights caused due to the cropping up of insurgency problems. It appears that militarization of the realm by promulgation of the law, giving special power to the armed forces in aid of civil power for the last about 40 years or so has been continuing, and insurgency problems also in reality extending. There are countless accounts of the human rights violation by the security forces, by the insurgents and the armed underground groups, and projected upon the civilian population tremendously. Human rights violation in these insurgency-infested areas of Northeast are not only perpetrated by the security forces, but also by the armed rebels as well. There is limitation in the employment of coercive legal provisions only to deal with the insurgency problems. Political dialogue, conversation, studies and research to find out the causes of cropping up of insurgency would act as further remedies to keep peace, and provisions of the law will no doubt a major step in that regards. So friends, more next time. Have a good day. Thank you very much.